big doings in the courtroom down in Orlando, and we welcome back our friend Jeff Weiner, Orlando Sentinel Court Reporter. Hey, Jeff, welcome back. I told you we'd call on you. I didn't know it would be today.
Well, thanks for having me back so soon.
No, please, thank you. I know how busy you are. Okay, so the judge made some rulings, and correct me if I'm wrong. The judge ruled that the prosecution will be allowed to say in their opening statements at the trial on Monday that Trayvon Martin was profiled by George Zimmerman, but will not be allowed to say that he was racially profiled. Correct?
That's exactly right. The defense had asked the judge to block several phrases or terms from the state's opening statements kind of preemptively. These aren't phrases that the state has said explicitly they plan to use. It's things that the defense was worried they would. Among those, wannabe cop, vigilante, and probably most prominently profiled. The judge ruled for the state on almost all of those. She said that they can say that Trayvon Martin was profiled, that they can call Zimmerman a wannabe cop or a vigilante if they choose to. She did caution them that she does not want them saying that he was racially profiled, and that's actually not far out of line necessarily with what the prosecutor said. He said that he didn't anticipate the state would try to say that he was profiled solely by race, and then went on to say that in his estimation there are a number of ways someone could be profiled: clothing, etc., age. So it was mostly a victory for the state, but it remains to be seen whether they'll go so far as to say wannabe cop in their opening statement.
Right. Well, yeah, and you know, to me, in this day and age, unfortunately, profiling has become a dirty word, when in fact profiling is what we all do. We're asked in this post 9/11 world to if you see something, say something. So in our mind, we're profiling what we see. If we see a package that looks suspicious, if we see a person that, for whatever reason in our mind, looks suspicious, that we're exercising profiling. Cops, if they're looking for a white male in a car with a blue hood, they're profiling. So even though profiling is legitimate police work, and you know, if by profiling they mean that he saw a guy who looked suspicious to him because of what he was wearing, that's profiling. All that is normal and innocent enough in a normal world. But to me, the profiling has become synonymous with racial profiling, so they may not have to say it to get that message across.
Well, and that was the argument of the defense attorney, Mark O'Mara. He said the phrase he used was, it's like peanut butter and jelly, that when people hear profiling, they assume that it means, or they internalize that it means racial profiling. The judge basically said that, you know, during opening statements, the parties are allowed to say anything that they have reasonable belief that the evidence will ultimately show, and that she didn't feel that she could prevent the state from using that term despite O'Mara's concerns about it. What she said basically on the issue was, if they don't prove it, they don't prove it, and if they can't demonstrate that Zimmerman profiled Trayvon Martin, then the defense is free to point that out when they get to their closing argument. Another
one, Jeff, was, I believe, and this might be a word you left out, I believe confrontation or confronted. Right.
Yes.
The state will be allowed to say that George Zimmerman confronted Trayvon Martin. Now, how on earth is the state ever going to prove that?
That's a good question, and you know, the state very clearly stated in today's hearing that is their theory, that Zimmerman confronted Trayvon Martin. One would assume that that's going to have to be established through a combination of circumstantial evidence, things like the portion of Zimmerman's non-emergency call to police where he's asked, "Are you following him?" and he says yes. You know, but we know already there aren't going to be any eyewitnesses to how that confrontation, altercation, whatever you want to call it, started. The actual physicality of it. So it remains to be seen how the state will accomplish that. And even though they're going to be allowed to say that in opening, if they're not able to establish it in evidence, you may see the judge prevent them from saying it in closing.
Yeah, interesting. And one more, there was no ruling, and tell me how surprising this is, on that, or maybe there wasn't, I don't know it, on that audio tape, the screaming, will that be admissible? Will the experts be allowed to be called, as we discussed yesterday? So she's putting that off until Monday?
Basically, the judge came into court today and said that she hadn't finished her work on that. She wants to put out a written order, doesn't want to pronounce it orally. She wants it to be a written order. And she said it's not done. She said she would try to get it done by the end of the day today. If she doesn't, she'll work on it over the weekend, and the attorneys will get it first thing Monday. Now, that's leaving a very major issue up in the air, whether the state will be allowed to call their expert witnesses who say that it's more likely Trayvon's voice heard screaming than Zimmerman's. And it puts them in a difficult position because they now have to basically plan two different opening statements, or at least plan a part of their opening statement that they could leave out about the expert testimony. Because we can be sure that the state and defense, if the experts are going to be allowed to testify, will want to talk about it in opening statements.
Yeah. Well, one more question. What's the speculation that this leans more towards her not allowing it in, or the delay leans the other way, or there's no way to gauge it?
Well, it's difficult to judge what the judge is thinking, but in general, the state of Florida uses a standard known as FRI, which is relatively permissive. All you have to show is that if basically you have to show either that the technique is not new and novel, that it's not new technology or a new technique, or that if it is new and novel, that it's generally accepted within its field. So usually in a standard case, expert testimony gets in. It's usually not so much of a controversy as it is in this case.
Right.
The defense says basically that these experts are using something very new, something that's not typically done in their field.
We shall see on Monday. Jeff, have a great weekend.